Good evening and welcome to the Young Center for Anabaptist and Pietist Studies. I'm Steve Nault, Director of the Young Center, and so glad to see each of you here this evening for our annual Kreider Lecture. This evening, our presentation is by Dr. Frédérique Green, who is this year's Kreider Fellow. Since 2009, the Kreider Fellowship has supported 16 researchers from a dozen U.S. universities and from Ireland, Nigeria, and the Netherlands. And we are so grateful to Carol Kreider, who is with us here this evening, and her husband Ken, for endowing the Kreider Fellowship, which brings these scholars to our campus each year for access to the resources here and in Hess Archives, and then to provide their resources to us through their research and through the annual Kreider Lecture. Carol and her daughters are here this evening, and we should acknowledge that today is Ken's birthday. Tonight we'll be considering patterns of interaction between the Amish and the state through the lens of both constitutional structures and cultural systems of negotiation. And we'll be hearing from Frédérique Green, a teacher from the United Kingdom with dual French and British citizenship. She holds a PhD from the University of Birmingham. She is no stranger to Elizabethtown and has been here several times in the past and has attended and spoken at Young Center summer conferences. This semester, she has continued to research in her area of expertise because the common law is not static, as she says, and Amish communities are not static either. It's been delightful to have her here this semester, and I know she has enjoyed getting to know many of you during these weeks that she has been here. So welcome, Frédérique.
Well, good evening. It's so lovely to see you all, familiar faces. It's encouraging. Thank you. So tonight we are going to look into the analysis of the interaction between the American politico-legal system and the Amish Christian minority using three models. So technology has to work. Yeah. So before I start this lecture, I want to give my thanks and appreciation for all the help I received during my time at the Young Center, not only this time, but before as well. I would not be standing before you tonight if it were not for the late Dr. Ken Kreider and Professor Carol Kreider's contribution and dedication to the Young Center. I am truly indebted to Dr. Donald Crable, Dr. Stephen Nault, Dr. Karen Johnson-Weiner, who is not here tonight, Dr. Jeff Bach, and the late Steve Scott, who welcomed me in 2011. My Amish friends, and I can say that tonight I have the privilege to have people who welcomed me in 2011 on their farm, Ben Lapp and his wife, and I've been in touch since. So thank you, Ben, for being here tonight. Thank you, Margaret. All my interviewees and, of course, my late husband, Mark, to whom I dedicate this presentation tonight. All of you have been instrumental in my research. An anecdote now. Although we had a shaky start with Professor Don Crable when I first came in 2011, I am very thankful for his inspiration and his help. The shaky bit goes like this. I sent an email to Don asking for an interview as I was writing up my dissertation. This word is key. He kindly accepted to receive me at the Young Center, and at the start of the interview, he discovered, to his dismay, that I was a mature undergraduate student. Yet it was clearly mentioned in my email. The eureka moment came when we understood that dissertation in the UK education system is the last piece of the equivalent of the US bachelor's degree, whereas dissertation here is the PhD masterpiece. After this, we proceeded. Since then, Don's generosity and sharing the fruit of his research and his encouragement have been vital. To cut a long story short, I eventually finished my PhD research and took my viva. Dr. Nolt was my international examiner, and Dr. Rhiannon Grant was my national examiner. During my research, Steve was extremely helpful as he connected me with key players in Indiana, and Dr. Karen Johnson-Weiner did the same in upstate New York. Jeff Bach was always welcoming when I came to present papers at several Amish conferences and has been a great encourager all along. Now, why on earth a French native married to a British man would be interested in the Amish Christian minority living in the USA? A bit of background will show you how I became so interested and passionate about my research. Countless people mentioned the film, which came out in 1989, Witness. That piqued my curiosity as well. However, my interest was fired up when more than 30 years ago, I met a couple of Mennonites who visited some friends in Paris. They graciously answered the million questions I asked about the Amish and the Mennonites. After that, I read all I could to explore the subject in greater depth. My previous studies in French law and international commerce underpinned my interest in law and languages, while my further studies in theology and religion contributed to establish a strong foundation for my research. Literature on Amish groups is now abundant, but when I started, two names were at the forefront: John Hostetler and Donald Crable. As I was conversing with their writings, I was intrigued by their concept of negotiation. More on this later. Now let us proceed to examine my topic more closely. Sorry. Yeah. So here is the outline of my presentation: introduction, methodology, part 1, the negotiation model, part 2, the constitutionalism model, part 3, the hybrid model, part 4, assimilation of the Amish, a puzzle to solve, and conclusion. In this lecture, I share my findings regarding the interaction between the American political-legal system and the Amish Christian minority at all levels of government. Come through, and sit down, please. Thank you. I consider in particular the way in which authorities approach the Amish difference. My qualitative research included semi-structured interviews of American authorities in Indiana, Ohio, upstate New York, and Pennsylvania, and a sample of influential Amish people. I will go into more details about my methodology a bit later. I am using case studies to emphasize the relationship between American governance and the Amish. Earlier scholarship, notably by Donald Crable, has mostly advocated a negotiation model operating between governments and the Amish groups, in which legal disputes are settled through mutual understanding. I suggest an alternative model at work to bridge the tension between the American democracy and the Amish theocracy. My analysis of empirical data confirmed that the principle established by the founders in the Bill of Rights and following amendments attached to the American Constitution were sufficient to protect freedom of religion and equality before the law for all American citizens, including Amish sectarian groups. I suggest that the negotiation model can still operate at local level, but that there is an alternative, my constitutionalism model, which also describes the way the Amish respond to state intervention. A third way appeared when I explored further my data and literature, my hybrid model. It summarizes the overlapping between the negotiation model and the constitutionalism model. My research also opens new perspective in understanding how religious groups with constitutional rights may progressively assimilate into the American liberal democracy. Before advancing further into the topic, I fully recognize that the American judicial institution navigates a complex system of deal-making or negotiation in court cases. My conviction is that the intention of the Founding Fathers was to outline a structure that could only function within the boundaries of the Constitution and the rule of law in general. So in 1993, Donald Kreider edited his seminal book, The Amish and the State. You have some copies outside on the table for those who would like to read that. In that book, Kreider suggested that relations between the Amish and the state could be interpreted through a conceptual framework of bargaining and negotiating. This assertion prompted me to investigate the concept further. The essays included in the book, The Amish and the State, followed the negotiation model thread. The authors examined frictions between the Amish and the state from the Amish perspective. The innovation in my research is twofold. First, building upon Hostetler, Kreider, Nolte, and other scholars on Amish life who worked from the Amish perspective, I decided to lead my research from the state point of view. Second, using NVivo 12 software brought a more scientific approach to the analysis of my empirical data. A few words about my methodology. As already said in the introduction, I used a qualitative research method, including semi-structured interviews, which means that I started a set of pre-prepared questions, followed by others that emerged organically during the conversation. When choosing the sample, I implemented a purposive method. In other words, I selected individuals or groups who represented the target population. For example, in a legal and judicial context, as well as Amish groups, also including a broader population of non-Amish American citizens. All of them would potentially provide a wealth of information underpinning tension between democracy and theocracy. My participants had to have a connection with the old order Amish groups. The internet was a godsend tool because it allowed me to easily find contacts. Not Amish contacts, though. You know that. I think at that time I was rather bold to secure interviews with key people. For example, I emailed the director of the Office of Public Information of the Supreme Court of Ohio, and I received an immediate response. He was very helpful and gave me a few names of several judges, attorneys to contact, and thanks to his recommendation and the snowballing effect, the interview of one attorney led to the interview of federal judge, etc. A newspaper article in Holmes County, Ohio, led me to contact with the courthouse in Millersburg, and from one judge, again, the snowballing effect generated other interviews with another judge, an attorney, an Amish bishop, and so on. In technical terms, I used an exponential, non-discriminative snowball sampling, meaning that all people referred were included. During my 3 extensive field trips, I traveled across Indiana, Ohio, Pennsylvania, and upstate New York, which gave me an overview of differences between states in their approach of their Amish local population. Defining my sample, I conducted 46 interviews involving 50 individuals. There were 39 males and 11 females. Most of the participants were over 40 years old. My sample was sizable and sufficient. It was composed of 10 people working in the political, legal, and judiciary sectors. 7 were local authorities. 6 worked in the health social sector. 7 were non-Amish business people. 8 were in academia, and 12 were old order Amish leaders. Interviews took place in a Congress office, in courthouses, in county commissioners' offices, in a bank, and for Amish participants in their office or home. More details about the role of my interviewees in society. So, Congressman, the representative from Pennsylvania in Washington, D.C., a federal judge in Ohio, common pleas judge, probate court judge, juvenile court, 5 attorneys in different states, prosecuting attorney, sheriff, who now is a commissioner, county commissioners, 3 more, planning commission directors, sanitary and environmental director, which is important for a story I'm going to tell you later, health and social services in Pennsylvania, a physician in New York, business people in Pennsylvania, Ohio, Indiana. Academics, 8 in the 3 states, Amish old order, 6 in Pennsylvania, 2 in Ohio, 3 in Indiana. So to sharpen the analysis of my empirical data, I use the NVivo. It goes a bit too fast. The NVivo 12 software. What is the NVivo 12 software? It is a tool that helps to analyze quantitative data, which are interview transcripts. I think the latest version is NVivo 15. It helped me to manage code and make sense of a large volume of interviews. It also helped me to identify themes, patterns, and visualize relationship between concepts to achieve a deeper understanding to support or refute my theory. So looking briefly at the technical side of NVivo, there are several steps to follow. Transcription of interviews in a Word document following a specific format, export of data into NVivo 12, launching queries, transfer to an Excel document, and choice of visual presentation of results. So I give you an example. When I launched a query on a question, I asked my non-Amish participants, to what extent do you feel that church and state are separate in America? So you can see on the right-hand side, the yes, very frank yes. On the left-hand side, fuzzy answer, yes, but. And the central part shows a balanced answer on how it actually works. Enough of methodology now, moving on to the negotiation model. The first notion of negotiation with the state in relations to the Amish was developed by John Hostetler. He explained that the Old Order National Steering Committee, quote, was formed in 1966 to negotiate directly with selective service officials to solve the problems connected with conscription, end quote. Later, Hostetler added that in the early 1990s, members of the committee sometimes engage, quote, in intense and protracted negotiations with local authorities, end quote. Kreider, in his book, The Riddle of Amish Culture, first published in 1989, defined his own idea. negotiating with modernity. It included a few points and there we go. Okay, so first point, literal face-to-face bargaining between Amish and representatives and government officials. Example, Amish schools, zoning regulation. Point 2, implicit negotiations between two cultural systems done informally and quietly. 3, a way of understanding controlled and selective social change, for example, new technology. And fourth point here, negotiation used metaphorically in a symbolic way to capture the dynamic dialogue between Amish life and contemporary culture. As quoted in point 4 of this figure, Kreider uses the negotiation metaphor when exploring how the Amish society culture deals with the mainstream world and culture. He defines culture bargaining as, quote, when the negotiable items are values, ideas, beliefs, and ways of thinking, cultural phenomena, end quote. Hostetler also wrote about compromise or negotiation when examining how the Amish were able to obtain a compromise in the school controversy in Pennsylvania in the mid-1950s. My suggestion is that the personal context of Hostetler and Kreider might bring some light to the use of the negotiation word and strategy. John Hostetler was an Amish-born scholar from Pennsylvania. In his early adult life, he chose not to join the Amish church. However, he kept a close relationship with his Amish family. Following the path of academia in anthropology and sociology, he offered his insider knowledge of his Amish heritage to draw accurate picture of Amish society. Donald Kreider was born and grew up in Lancaster County, Pennsylvania. Coming from Anabaptist and agricultural background and growing up in the specific area where the Amish settled have given him credentials to understand and identify with Amish people. However, what seemed an asset in terms of accessing one of the most isolated communities in the 1980s might have been a drawback when processing data. My guess is that non-Amish people living in areas with large Amish population assimilate Amish parlance and their perception of life. Thus, Kreider's sociology approach, combined with his close interaction with Amish people, produced the concept of negotiating with modernity. My supposition is reinforced by my interviews of Amish and non-Amish participants who are well acquainted with Hostetler and Kreider, who both intentionally and often use the word negotiation or synonymous expressions. An older Amish man who was for a very long time in position of leadership on the Old Order Amish Steering Committee said, quote, if something conflicts with our religion, we have to work something out with the government, end quote. One of his younger colleagues talked about the same process. Quote, we have some elected officials in our area who have been very helpful to us, and we can use them to get the message across, as far as negotiating, yes, we do some, we sit down with them and we talk with them across the table, if need be, end quote. This sentiment echoes Kreider's assertion found in point 1 of this figure and in the book, The Amish and the State. In Kreider's work, the interpretation of the term negotiation and derivative words is fluid. The negotiation with modernity concept of riddle slips smoothly to the negotiation model of the Amish and the state. Subsequent book chapters on the relationship between the Amish and the American government have multiplied, supporting the negotiation idea. Although I agree with Kreider on the internal, social, and cultural negotiation flux, I have reservation when it comes to the judicial and legal spheres. At first, I was convinced that my constitutionalism model was the answer to understanding how the relationship between authorities and the Amish communities function. However, through the process of interviewing, I discovered that the negotiation model was sometimes working at local level. In Ohio, a striking example drew my attention. Interviewing judges, a local commissioner, and Amish leaders, I discovered how the Amish of Holmes County, on hearing a rumor about a possible tax on their buggies, preempted the potential law. They voluntarily still collect money in their community and send it to authorities to contribute to road repairs. My Amish interviewee said, quote, "Yes, we drive horse and buggy. I don't use up a lot of gasoline, so I'm not paying for the road. So we have a voluntary instead of, since we don't have license plates. So we make up, gather $500,000, and we send it to Columbus, and the state gets a little bit, the county gets some, and some comes back to the town to help repair the roads that they say our horses tear up," end quote. That was in June 2016, so the amount of money collected may be higher now. 2 years later, a county commissioner in Holmes County again reported to me, quote, "So you know, much like the buggies you see on the roads where we buy license plates and pay fuel taxes, they pay $50 per buggy into a fund to help maintain the roads. So it isn't like they are not helping in the community. They do," end quote. Although it is not bargaining with authorities in the first sense of the word, it is a clever way of avoiding a connection with the authorities, thus the world. This example fits the negotiation model. Still, in Indiana, in Adams and Elkhart counties, Amish people pay their buggy tax and display a registration plate on their buggies, as you can see here. It's a bit small, but here. In 2018, in Adams County, Indiana, a Schwarzentruber Amish man explained to me, quote, "It costs $120 per year on each buggy. We have around 2,000 buggies with a plate on. You do the math. And we have to have a sticker. Some suggest we are freeloaders. Over half of the road county will not be traveled by horses and buggies," end quote. In Holmes County, Ohio, the negotiation model prevailed. In Adams County, Indiana, the authorities voted Ordinance number 2017/6, taxing horse-drawn transportation. There was no negotiation. These examples show differences between counties within the states of Ohio and Indiana. After this little horse and buggy detour, let's examine how my Amish and non-Amish interviewees replied to the question of the possibility of the Amish to negotiate with the state. Bless you. I compiled their answers and the results appear in the following graphic. On the horizontal axis, the number of persons interviewed here, and who had an opinion on that question. And on the vertical axis here, you find, the number of times people mentioned words and expressions related to the concept of negotiation with the state. The orange or yellowish trend represents the Amish interviewees. The blue trend represents the non-Amish interviewees. Undoubtedly, Amish participants associate law with the negotiation process. You can see the orange high bars, whereas the non-Amish participants present lower score in blue. The non-Amish higher scores in blue indicate a close interaction with the Amish. They comprehend their peculiarity. Part 2, moving on to my constitutionalism model. My theoretical framework is rooted in the in the American Constitution of 1787, the Bill of Rights and subsequent amendments. More precisely, I consider that the foundational principles set forth by the founders in the First Amendment and extended in the 14th Amendment are still valid in the 21st century. Refreshing our memory, the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. And the first section of the 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. To simplify, free exercise of religion and equality before the law are the two pillars that support my constitutionalism model. My reasoning is that since the Amish arrived in America in the early 17th century and the 1700s and the 1800s, they have gradually become part of the American fabric. Although they want to keep separate from the world, legally they are American citizens. When the U.S. foundational documents were drawn up and ratified, it consolidated protection of freedom of religion and equality before the law for all citizens, including the Amish. Therefore, even if in Amish parlance they negotiate with the state, for instance, meeting with representatives or senators, they are doing so because the Constitution, the First and 14th Amendments, are the frames within which they can operate. In English parlance, they are lobbying to obtain relief from laws that would encroach in their way of life. However, lobbying is in contradiction with the two-kingdom theology, as Kreider explained. Quote, followers of this theology should not try to influence the government in its policies and lawmaking. They should not interfere with government decisions. End quote. A concrete example. Frictions taking place between the state of Minnesota and a group of Schwarzenegger Amish in environmental issues clarify how my constitutionalism model operates. To set the scene, in 2018, the 5 ABC Eyewitness News television headlines said, "Religious freedom clashes with environmental law in Minnesota court." The case between the County of Fillmore and Minnesota Pollution Control Agency versus Amos Mass et al. Started in 2013. In October, Minnesota Pollution Control Agency issued rules regarding treatment of gray water that they define as wastewater produced from laundry, bathing, and cooking activities, and which does not contain toilet waste. In December 2013, Fillmore County tried to compel the Schwarzenhuber Amish to install a septic system for gray water. They refused to do so on religious grounds, but they were ready to adopt a more natural system that recycles the gray water known as a mulch basin system. This system is permitted in other states, Wyoming and Montana, for example, and it would comply with their ordnung, or internal rules of their Amish communities. Despite the appearance of a negotiation happening between authorities and the Amish, the judicial case was already initiated. The judicial procedure progressed yearly from district court to the Court of Appeals to reach the Minnesota Supreme Court, and so on. Meanwhile, during the fall of 2017, the Amish built their mulch basins with the county staff, which the county staff observed during an inspection in the summer of 2018. Nevertheless, the court case continued to roll on, and in 2021, the U.S. Supreme Court granted review of the case and sent it back to the Minnesota Court of Appeals. Using different cases to illustrate their point, justices of the U.S. Supreme Court agreed on the fact that the lower court plainly misinterpreted and misapplied the Religious Land Use and Institutionalized Persons Act of 2000. This act is a federal law protecting religious institutions and individuals from land use policies that create significant hurdles for religious communities. It prohibits governments from imposing a substantial burden on religious exercise unless it is absolutely necessary. Justice Gorsuch offered 3 ways to review the case. First, the issue is not whether the county has a strong reason to enforce its septic system rules in general, but whether it has a good reason to refuse an exception to the Schwarzenhuber Amish. It is also the government burden to prove that the mulch basin solution would not work, not the Amish to prove to the contrary. Second, they need to consider the sort of exemptions the government gives to other groups. For example, thousands of campers, hunters, etc., exempt from the septic system mandate. Third, the court must take into account how other jurisdictions have allowed exceptions for religious groups. In 2023, Judge Diane Bradford from the state of Minnesota Court of Appeals gave her a decision which is, quote, reverse and remand. To put it another way, the Court of Appeals overturned the decision of the district court due to an error in interpreting and applying the religious land use. So the court admitted that, quote, the Amish Schwarzenhuber's sincere exercise of religion was substantially burdened, end quote. Consequently, the government had to make a strong case for enforcing the rule to the Schwarzenhuber. In the meantime, the government was barred from implementing that rule. This long ordeal came to its conclusion in March 2025, when the two parties decided to drop the case. Behind the scenes, between 2023 and 2024, the two parties legally settled an agreement approved by the judge. It established a very strict contract on the enforcement of environmental regulations by Minnesota Pollution Control Agency, allowing the specific Schwarzentruber Amish community of Fillmore County to request a religious exemption within very rigorous limits. The timeline of this case highlights that from local government friction in Fillmore County between the Minnesota Pollution Control Agency and Schwarzentruber Amish to the U.S. Supreme Court and back to lower courts, the terms of the U.S. Constitution govern the interpretation of settlements and disputes. Amish American citizens of the 21st century are engulfed in a whirlwind of administrative regulations. Even the extremely conservative Schwarzentrubers filed a lawsuit with the help of an English driver, as their attorney Brian Lipford from Minnesota informed me. With the permission of the Amish, the driver contacted the attorney's office and started the ball rolling. It took 12 years to legally settle this case. The root of the American judicial system is found in the U.S. Constitution that either established the courts, in the case with the Supreme Court, or authorizes Congress to establish them. The American government at all levels is part of the Amish American citizen's life, even for the most traditional portion of Amish folks like the Schwarzentruber. In 2018, when I interviewed Commissioner Doug Bowman from Adams County in Indiana, he explained having the same difficulties with ultra-conservative Amish in his county. Amish were illegally disposing of human waste. They refused to comply with rules demanding that septic systems were installed on their properties. In a letter, Amish leaders stated their position. Quote, "One reason we don't want the tanks and the black water systems, it would be very easy for our members to hook up flush toilets. They still use privy. So you could say we oppose this on religious grounds," end quote. To consolidate my constitutionalism theory, using my NVivo 12 again, I gathered and analyzed answers to my question. In your opinion, is the First Amendment of the U.S. Constitution regarding religion an effective tool to negotiate with the states? The results appear in the next graphic. On the horizontal axis, the number of people responding to the question, and on the vertical one, the number of times people mentioned words or expressions related to the concept of constitutionalism. The orange trend represents the Amish interviewees, and the blue trend again represents the non-Amish interviewees. Evidently, the non-Amish highest scores in blue indicate excuse me, a clear awareness of the American citizens' rights granted by the First and 14th Amendment. In contrast, the Amish respondents present low scores in orange. They have an implicit knowledge of the First Amendment, excuse me, but their verbal expression when it comes to the law and lawmakers is more restrained. This reserve can be explained by their inherent sense of modesty, practice of humility, and also to the dictates of their ordnung. Part 3, my two graphics on the negotiation and constitutionalism models are not the end of the story. I now turn to the third model, the hybrid model. Despite the firm intention of the framers to keep state and church separate, and the Amish separation from the world embodied by the, excuse my pronunciation, Schleisheim Confession of Faith, Article 4 of 1527, I identified a porosity in this double wall of separation. On the state side, court cases prove that the state can accommodate religious minorities like the Amish. Wisconsin versus Yoder in 1972 is one of them. The U.S. Supreme Court ruled in favor of the Amish, accommodating their religious tradition of ending their children's schooling at 8th grade. This ruling was possible in the context of the early 1970s and within the frame of the First and 14th Amendment, which shows that my constitutionalism model is valid. The third model in operation, or the hybrid model, as I mentioned earlier on, in agreement with Kreider, Steve Nolt asserts, quote, typically they, the Amish, relate to government as subjects rather than as citizens. In other words, their preferred mode of operation is to quietly petition or negotiate for exemptions and special privileges rather than to litigate, lobby, or invoke their constitutional rights, end quote. This statement describes the Amish viewpoint of their relationship with government. The following example illustrates how my hybrid model operates, combining both the negotiation and constitutionalism models. The Amish worked with Congressman Joseph Pitts of Pennsylvania and his team regarding the amendment of the Fair Labor Standards Acts of 1938. The amendment of this law, allowing Amish youth to work in woodwork shops following safety guidelines, was signed into law by President George W. Bush in January 2004. That could be interpreted as negotiating with the law. However, while I interviewed Congressman Pitts, he declared, quote, I interceded with the Department of Labor, and they would not reconsider allowing Amish youth to work in woodwork shops. They said the law had to be changed. I had Amish come from 20 states to Washington, and we met, and I listened to all of them. We tried to get the Department of Labor to make some accommodation. They would not. So, finally, we drafted legislation, end quote. Here is the fact sheet number 55 from the United States Department of Labor entitled Application of the Federal Child Labor Provisions to the Employment of Minors who are exempt from compulsory school attendance in businesses where machines process wood products. As American citizens, the Amish were able to approach their congressman. The process to promote a new legislation or amendments is the same for everyone. In other words, they lobbied government within the limits of the law like any other American citizen. The blending of discussion with a Congress representative and the process of changing the law illustrates my hybrid model. Overall, the negotiation model can work at local level. At state level, the hybrid model can function because American citizens have access to their state representatives and senators to present their petitions. However, judicial and legislative tools are used at federal level with no real negotiation in the sense of bargaining. I compiled a table showing the interaction between the US government and the Amish minority between 1935 and 2018. Part of the assimilation process for some Amish found in their growth of American laws and how competencies in knowing and using their American citizens' rights, sometimes by themselves or helped by English outsiders. So this table gives a synoptic view of this phenomenon. I do apologize because this is a busy slide and not really legible, but I will explain it to you. So, 2018 is here in this central bar. The upper part here records the upper part records American government laws that directly affected the Amish religious minority, and the lower part shows the Amish response to those laws. This table pictures how my constitutionalism model is the larger framework within which the Amish actively work under the protection of the First and 14th Amendment of the Constitution. However, my hybrid model is illustrated by the Amish leadership interacting with congressional politicians to obtain a number of exemptions. The table does not include Kreider's negotiation model because negotiation between local authorities and Amish leadership would include too much data to collect in a synoptic manner. However, negotiation can be possible in certain cases and certain geographical areas. My hypothesis is that the steady increase of law at all levels and in every sphere of the American nation clash more and more with the Amish way of life and might gradually lead to some Amish group assimilating more into the American society. To picture my theory, this graph shows the number of pages in the Federal Register between 1936 and 2024. The Federal Register records laws and regulations on American society, and the number of pages have increased by almost 40% between 1936 and 2024. Increasing laws and regulations potentially have an impact on religious minorities like the Amish. In parallel, litigations can increase, challenging the separation between church and state, and the third body of government or judicial power has to test and interpret these laws. The negotiation tool of the Amish might eventually disappear under the pressure of legal actions conducted by authorities, for example, in zoning issues, in environmental matters, and other problems. As American citizens abiding by the law, the Amish are already equally integrated in the American nation. Their religious beliefs and practices are firmly protected by the First Amendment, which can presumably help them push back the infiltration of secularism within their community. Assimilation of the Amish, a puzzle to solve. I suggest that some very progressive Amish groups are on the path of assimilating within the secular American culture. Although not using the word assimilation, Karen Johnson-Weiner relates how, quote, life for many Amish is no longer strictly defined by the ordnung or contained within the boundaries of the church community, end quote. The impact of a combination of contextual factors shows a leaning in this direction. For example, geographical, economic, and cultural variations are revealed in Elkhart County, Indiana. Amish people, including Amish young women, work in recreational vehicle factories. As I witnessed in the same area, there are visible signs of social and economic differences. Their houses and gardens give the impression of being middle class, like non-Amish houses, compared to the very traditional Schwarzentruber properties I visited in upstate New York. In Holmes County, Ohio, some Amish young people learn computer skills and some take their GEDs. Commerce related to the wood industry, as I saw in Bell Center, Ohio, or Lancaster County, Pennsylvania, lead Amish craftsmen to regularly exchange with English customers, buying kitchen cabinets or ordering house framing. Tourism is also a major factor of transformation in Amish culture due to the constant use of the English vernacular to communicate with their English-speaking customers. Although it is impossible to encompass all the Amish tribes in the example I gave above, a large segment of the Amish is less separated from the world and definitely more involved with it. My hunch is that these pressures put in danger the stability of their core Amishness, to use a word coined by Johnson Winner. Generational variations are found, for instance, in the way younger Amish people do not mind having their photo ID, whereas it is an anathema for the older generations. Casting vote is also seen by some younger Amish individuals as being part of living and participating in American life. Here is a photo that speaks volume about the change of attitude that is happening in some Amish groups. We can see a young Amish couple coming out of the poll station, and they didn't mind being photographed and named in an article written for Anabaptist World in November 2024. This latter point leads me to my conclusion. Using the three models at our disposal, I analyzed the ways in which American governance engage with the Amish. It appears that since the middle of the 20th century, the more progressive Amish have taken on board the American channels of political and legal action. As shown in my synoptic table, they obtained relief in the Social Security area in 1955, 1965, 1988, in selective service in the mid-60s, in child labor 2004. In 1966, they created the Old Order Amish Steering Committee that centralized the Amish voice for the most part. This institution, between inverted commas, helps them navigate the notionally secular American political and legal system. At times, the continual increase of laws, rules, and regulations imposed on American citizens encroach in the Amish way of life. The response to government control is traditionally to refuse to comply with worldly laws that encroach in their beliefs, meaning that their first allegiance is to the Christian God. Although they want to keep separate from the world following the Bible's teaching, they also respect government as it is outlined in their book, 1001 Questions and Answers on the Christian Life. The Amish duty is to pray for them, government, 1 Timothy 2:2, obey them, Romans 13, verse 1, pay taxes, Romans 13, verses 6 and 7. Nevertheless, in many instances, Amish communities have to bend the rigidity of their ordnungs in order to obey government laws, which are intractable. However, the new generation appears to be more at ease in their American citizenship without renouncing their heritage. From the governance perspective, it seems that over the past generations, American authorities at the federal, state, and local levels have recognized the potential effects of new laws and regulations on different religious minorities like the Amish, allowing a few accommodations to exist despite the intended separation between church and state. Indeed, the relationship between American governance and the Amish communities is likely to develop organically, inviting continued observation of their interaction in the future. Thank you for your attention. Thank you. If you have any questions, it's time to fire away, shoot. I'm not sure I can reply to all of your questions, but I'll try to do my best. Yes.
One of the things I wondered about is that we hear so often in various seminars, lectures, about how often people from the Mennonite or Amish background fled to another place when they could no longer be able to live where they were because of their refusal to submit to governmental laws. And I wonder if you ran across any of those kinds of ruminations among people about how previous generations would have left the remote or whatever the response might have been.
I think the question is about if people, Amish people move away from the place they are. Is that right?
The Anabaptist groups would simply, as a colony, move on to something else.
Because of the rules and regulations they didn't want to be under, right?
The government in that area was not going to negotiate.
Accommodate, yes, okay. Yes, I've come across that when I went to upstate New York, and I visited Schwarzentrube, and a lot of them came from Pennsylvania, where they felt that they were under the law. It was too hard for them, and so they went up to New York State, and where they could live in their way. In their ways without too much problems. That was several years ago. I don't know what it is now. Excuse me.
I have a question. How would the French or English government relate to the Amish compared to what you see in the United States?
The answer is very simple. We do not have any Amish in our countries in Europe. You are all here in America. I just heard that, excuse me, some more progressive Amish have installed some colonies in Ireland, but I haven't visited any of them. So I don't know how they live. Excuse me.
But my question is, they
Sorry.
liberty there and to do in America?
Probably not. I think the First Amendment is helping very much the Amish communities, and they are protected by this First and 14th Amendment. I think they would have to submit to the law in Europe. We are very square and Cartesian in France particularly. Yes?
You know, after you come back, say 2 years, and describe how the First and 14th Amendments still apply.
Okay, so I should come back in 2 years' time to see if the First and 14th Amendment are still applicable, right? Well, thank you for the invitation.
Not just to the Amish community, but to the non-Amish community.
No.
Because everybody, because, well, I'm not getting into a political discussion, but they're being rude.
Okay, so in 2 years' time, we'll see how the First and 14th Amendment are coping under certain administration. Is that right?
Yes.
Okay. I don't know. Yes?
So it's my understanding that sometimes in cases of sexual abuse, when Amish victims would go to court, the authorities, the local authorities would do what sounds like negotiation and allow the Amish community leaders to deal with it.
Mm-hmm.
I know you talked about policies and agriculture and zoning. And do you feel like some things may be open to negotiation and some things should never be modeled in negotiation?
Yes, I suppose so. I think the question was about sexual assault in Amish communities and how it is negotiable or not, right? I came across some cases of Amish sexual assault, and at the beginning, the people, former generations, were pushing it under the carpet. In Pennsylvania, I'm aware of some groups who have organized serious connection with the state, as in being helped to deal with it, and they have created some parallel institution to help people who have been abused. But this is under the control of Pennsylvania state. I don't have the details about those, but it used to be the Amish community dealt with it within, and bishops dealt with it. Now it's different. They have to go through process. Mm.
Yes, I've heard some discussion about how there were some bishops would load up their people on bus and take them to the polls and tell them how to vote. I don't know if you've heard this, or if there's any discussion as to the power of the bishops in telling people how to vote in the election.
Depending on the Amish community, I think, as in any communities, you have people who have a power over their people, and some others who say no, it's in your conscience to vote or not. I suppose some might advise their people how to vote, but I don't think it's something that they are coerced to do. The general law is you don't vote. We do not vote. And all the people I came across said, usually we don't vote, or if people do, it's on their own accord. But I suppose the spectrum of you vote, you don't is very wide in different communities.
Have you seen instances or perhaps even trends of Amish people serving at the local level in governmental positions? Not paid positions, but elected or appointed positions.
Amish people serving in local communities? I haven't heard of any of them at the moment. Historically, I think they had people serving in Ohio, but it was a long time ago. I think now they are serving more on their own school committees and things like that. I'm not aware of any Amish serving in American. Do you know some? And in what capacity do they serve, please?
So planning commission.
Yes. Okay. Yeah.
So it's the one position that impacts their community heavily.
Yep.
So
So he I suppose he serves in planning commission. The person serves in planning commission. Yeah, here in Pennsylvania.
yes.
Okay. Yes, that's possible. Yes. Yes.
Of the 12 Amish that you interviewed, how many were female?
11. Oh no, Amish female. No, 2, 3 were sitting. That's why I said I interviewed 40 people, but 50 were in the interviews, because the ladies were sitting, 3 of them, with their husbands, but didn't interfere with what the husband was saying or was in agreement with him. But most of them, it was Amish men. Yes.
What about the expense of these processes to get a law changed? how do they handle that? Who finances this?
Sorry,
To pay for legal counsel, to pay for whatever court costs, how do they deal with that? Yeah.
well, some of them have a community pot to help, and otherwise they have pro bono. Depends on pro bono. Pro bono, how would you say that? Yeah, pro bono. Yeah. So it's paid for them. Depends in of the circumstance and when and how. I don't know. Mhm. No more questions? Okay, you're ready to go home. Thank you very much for coming tonight. Thank you.
Thank you very much, Frédérique, for sharing with us this evening, and thank you for being here this semester. We've enjoyed having you with us this semester. We need to wrap our time this evening, and I again want to thank Dr. Green for sharing with us this evening, and also make one announcement about our remaining upcoming event for this spring semester. On Thursday, April 30th, 3.5 weeks from now, we'll be hosting a one-day seminar reassessing the missional element of early Anabaptism and its implications for today, led by another visiting fellow at the Young Center right now, Dr. Nelson Okanye. The seminar will convene at 9 a.m. and run through 3 p.m. and will include lunch. Born and raised in Kenya, Okanye serves as chair of the Mennonite World Conference Global Mission Fellowship and holds a doctorate from Fuller Theological Seminary. Seminar participants will receive in advance a copy of a working paper by Okanye, and the seminar will center on a dialogue around the themes developed in that paper. There is no charge to attend the seminar, but registration is required by April 24th in order to distribute the paper and to make accommodations for lunch. Register by calling or emailing the Young Center by April 24th for that Thursday, April 30 seminar that will be here at the Young Center from 9 to 3. Thank you for attending this evening. Safe travels as you return home.